Hi everybody, and thanks for tuning in to this unorthodox method of instruction. But as we near the end of the semester, we're kind of running out of days, so normally I'd give you a free pass on a day I couldn't make it, but anyhow, here we are. So I'm going to pick up right where we left off from class on Wednesday. We finished talking about this case, U.S. versus Darby. And I want to highlight the distinction in Darby and what we sort of learn in Darby. At this point, 1941, commerce is all things. It is production, it is manufacture, right? Or more specifically, what we learn in the NLRB case is that the things that affect commerce, things that are not themselves commerce but are inextricably linked with commerce, can themselves be regulated by Congress. So here in Darby, we find that Congress is able to regulate the labor practices of a mill, because that mill, even though they're using intrastate labor and most of their stuff is going on intrastate, they ship their lumber out of state. So even then, Congress is able to regulate. So we get this distinction between Dagenhart, the child labor case, and Darby, where the court explicitly overturns Dagenhart. They're saying we don't recognize this distinction between manufacturing and commerce anymore. Congress doesn't really. Congress knows that businesses don't think about where the goods are going to go. They produce them, and then the market decides where they're going to go. That doesn't mean they're not engaged in interstate commerce. So, in Darby, we kind of get rid of this meaningful distinction between manufacturing or production by other means and interstate commerce. Okay. So at the end of the day Wednesday, we started discussing a different case, and I sort of tricked you with one, but we did talk about a real case, and now we'll kind of walk through that real case. That one's called Wickard versus Filburn. This is just 1 year after Darby. So we can see here, is the court going to sort of double down on this new idea of commerce, where Congress has this very expansive ability to regulate intrastate commerce that affects interstate commerce. So the story here is that in 1938, Congress passed the Agricultural Adjustment Act. So the Secretary of Agriculture was able to decide what the limits on the production of certain grains would be, and the reason for that is overproduction made the value of a grain at market effectively zero, right? Where there's unlimited supply, that means there's no demand, so there's no value for the good. So if they were able to regulate the supply, the demand would go up. Well, the demand would stay the same, but the price would go up because the supply was more limited. So Congress wanted to stop these crazy price swings for grain. They wanted grain to be worth something. So they enabled the Secretary of Agriculture to place these limits. Roscoe Filburn had a family farm. He raised winter wheat there. He sold some of it. He used some of it to feed his livestock, and the rest he was feeding his family. You know, this is a pre-Atkins diet world. So in 1940, he was told by the Secretary of Agriculture that in the next year, he was only allowed to grow 11 acres. He planted more than that, and he ended up being fined for the 12th, 13th, whatever, anything beyond 11 acres. And he said, I'm not going to pay this fine because Congress isn't allowed to tell me how much wheat I can grow. So a lower court agreed with Filburn, but Wickard, who was the Secretary of Agriculture, appealed up to the Supreme Court. So the pro-Wickard argument, the pro-U.S., the pro-Secretary of Agriculture argument is the quota, right, the cap on how much wheat somebody could grow, is a valid exercise of a congressional power. That power, of course, being the regulation of commerce. And the reason for that is because the excess wheat, the 12th, the 13th, the 14th acres that he grows, it ends up impacting the national supply. The national supply, of course, influences the price, and they want to stop the price swings. So Congress is, because they have the ability to regulate the market, regulate commerce, they also have the ability to determine how to do that the best. Here they decided that the quota should be on all the wheat available, not just the stuff that gets sold. So they decided, we're not going to tell Filburn, hey, you can grow 8 acres and sell it and do whatever you want with the rest. We're going to say you can only grow 11, and with that 11 you can choose what to do. He still could have fed his family and his livestock with some of that 11. He just couldn't grow more. This is a practical matter as well, because Congress can't exactly go out and check on all of the wheat producers, and say, oh, you grew 13 acres, you can only sell 11. They set the quotas and everything ahead of time, right? So it's sort of preemptive. Ultimately, this is a necessary and proper exercise, necessary to sort of get the effect of the law, which is to stop the price swings, and proper because it's meeting one of the enumerated ends, the regulation of commerce. Filburn, on the other hand, says this isn't even commerce, right? This isn't even trade. We're not talking whether it's interstate or intrastate. We're not talking about whether it's production or manufacture or what. It's not even commerce. This is about telling me what I can do on my private property. And Filburn says it's kind of crazy to say that the wheat that I use to feed my kids and my livestock is somehow part of the competition, that it's somehow part of the national supply, because it's a personal supply. So ultimately, the argument is that, sure, Congress can regulate, what ends up being interstate wheat, or interstate commerce wheat, but they can't regulate whether I benefit from my own product. Okay, so again, from Darby, we have this idea that even things going on in a single state can be regulated if they affect interstate commerce. That's consistent with Marshall's original opinion in Gibbons versus Ogden. Here, the question is, okay, does that apply on a really, really micro scale? And the answer to that is, yeah, it does. So the legal question is, can the Secretary of Agriculture place a quota, even if that grain is only being used for home purposes? And unanimously, the court holds that Filburn should not have grown the extra wheat. He wasn't allowed to. Congress can regulate how much wheat he grows, even if what he grows beyond that is for personal use. Excuse me. So the legal reasoning begins, a market includes disposing of wheat for the purposes of feeding livestock so that it may be sold at market. Further, excess wheat is designed as available for marketing, right? So they're saying there's not really a distinction between what Filburn could have sold and what he did sell, right? That's not really what's being regulated. So the other component of that is eventually the livestock are going to be sold. So the livestock are part of commerce. So the thing that feeds them is part of commerce. So the excess wheat, what fed the livestock, is definitely part of that market, right? And we kind of see the sort of the stream of commerce logic in there. Not exactly, but you kind of get the idea of all the things that go into the interstate commerce are themselves interstate commerce. Beyond that, if Filburn grew, let's say, 14 acres, he still could have sold 12 or 13. Just because he didn't doesn't change the fact that he could have marketed it. So the court says here, we're going back to Marshall and Gibbons versus Ogden, and we're going to affirm the holding in Darby. They write, the power to regulate commerce is emphatic and all-embracing. While the court strayed from this interpretation for many years, recent cases have begun to rely on Marshall's decision once again. So we're back to the Gibbons versus Ogden thing, Marshall's 4 original ideas of commerce. Everything in between, E.C. Knight about production and manufacture not being commerce, the stream of commerce stuff, all of that, the court is saying wasn't really correct. Now, they're not necessarily overturning all of that, but they're saying we kind of screwed up for a long time. They admit that the act was purely local. Obviously, it's very micro. It's on Filburn's farm. But they say because that can impact interstate commerce, Congress gets to oversee that. They say we do not hold that the effect has to be direct, right? So here we go. We're sort of done with this indirect-direct distinction. It's all about whether something affects commerce. They say another reason that Filburn's wheat is definitely interstate commerce is because he doesn't have to go out and buy the wheat, right? So again, if we're talking about supply and demand, Congress is initially worried about too great of a supply. But by allowing people to grow excess wheat, then it's an issue about demand. So if the ultimate purpose of the law was to regulate price swings, the idea is controlling both supply and demand to regulate the market. It has to work both ways. So again, even if he feeds his cows, his kids, whatever, it still ultimately influences the market. So this seems pretty crazy that Congress says, hey, Roscoe Filburn individually, you can't grow that much wheat. But the logic of it should apply sort of widely. You know, the court doesn't really care about Roscoe Filburn, and I don't mean that in a cold way. I mean that in a, what if Roscoe Filburn had 500 neighbors who all could only grow 11 acres, but all grew 20, right? So it's not about suppressing one person or whatever. It's about, if we're going to regulate one thing, we have to regulate all of it. If we're going to regulate a farm that's growing, say, 5,000 acres, we also have to regulate the guy growing 11. So I do think sort of the Darby ruling is a little easier to take here, right? It makes more sense that the lumber's being shipped out of state, so that is clearly interstate commerce, what have you. But the issue with Filburn, it's staying at his house, it's staying at his farm. It's a little more difficult to sort of get behind, but the logic's exactly the same. So finally, after all of the things we've been talking about for the last 2 weeks, the court's commerce rulings are finally pretty consistent and a fairly straightforward interpretation of the Constitution. No more of this indirect, direct, stream of consciousness, production, where does the stream end, all this type of thing. We're sort of at a more settled idea of what commerce is. Also in Filburn, we see the court kind of suggest previous courts had been unnecessarily regulating interstate commerce. It shouldn't have been restricted the way it was. And they say those definitions were unnecessarily restrictive. Right? So basically, what we get here is intrastate production, manufacture, transportation, labor, all these things. At the end of the day, they influence interstate commerce. Congress can regulate interstate commerce, therefore they can regulate the things that influence interstate commerce. So in the Darby case, one of Darby's complaints was, the quirk of a federal system where the supply is local but the demand is national cannot possibly mean that Congress has the authority to regulate what's happening in a single state. Well, that's obviously not true. The need to regulate, to have a single uniform standard for everybody so that there's no unfair competition and all these types of things, that is exactly what that system implies, where the supply is local but the demand is national. That precisely implies that there needs to be a uniform standard. And as we well know, anytime there needs to be a uniform standard, the only body to enact it is Congress. So we're going to see, and right now we're going to jump to sort of the next set of slides, but to preview it just a touch. This very expansive view that's born in 1941, 1942, it persists until the early 1990s. And the court had been growing conservative since the 70s, but in the 1990s they sort of reclaimed some of these issue areas, and I'll talk about why in the next set of slides. But for a long time, I guess I'll talk about it now. For a long time, the court struggled with, should Congress be regulating commerce like the economy, or are they allowed to practice sort of police powers? And we know from cases like Champion versus Ames that there's no difference, right? There are, in a sense, federal police powers because of commerce. It doesn't really matter if the thing being regulated is perceived as a social ill. My sense is that this expansive view of federal power via commerce persisted until the 1990s, even though the country didn't want economic regulations as much because it was that because Congress was using the Commerce Clause to correct the social ills of the day, right? So, there was a lot of civil rights acts that were struck down. The one that finally stuck, that we'll talk about in a couple of minutes, the Civil Rights Act of 1964. The logic behind that, or the authority behind that, is the Commerce Clause. So people were still interested in correcting these social ills, but they didn't want the economic interventions. So I think that's why the expansive view stuck around for so long. And right now we'll jump into sort of our third set of Commerce Clause notes. And we're going to talk about here sort of its rampant use, like this very expansive view, and then finally, not here in the audio notes, but when we meet back on Monday, we'll talk about some of the limitations. So we're going to talk about Congress went kind of crazy. I mean, they use this a lot. They use it sort of very minutely, even beyond some of the Filburn stuff. But ultimately, there are limitations. So much of what these notes are going to be about is sort of the modern day understanding of commerce, which has been around for, at this point, about 30 years. So as we just concluded with Filburn, right, we know that local actions that affect interstate commerce can be regulated. Right, so there's no direct distinction anymore. If Congress has what's called a rational basis for concluding that something influences interstate commerce, they could regulate it. Right, so we don't really get into what a rational basis means in this class, but just understand that a rational basis is like a connection between two things that is not tenuous. Right, it's like it makes sense to connect the thing being regulated with the use of commerce. So in this time, the court really hammered the 10th Amendment. They said it's a truism, does not inhibit the exercise of enumerated powers, and that sort of never really changes. I mean, we'll talk a little bit about federalism and what does kind of change, but as I've said several times, the court's never ruling in favor of the 10th Amendment. They're just saying Congress overstepped. Those are different things. So as I mentioned just a little bit ago, a lot of the things that Congress was using the Commerce Clause for were social ills. So the Civil Rights Act of 1964, instead of trying to ground its authority in something like the 14th Amendment, which has the Equal Protection Clause and the Due Process Clause, the Civil Rights Act of 1964 says Congress is allowed to make this law federally, and it applies to the states because of commerce. Right? So they thought this justification was going to stand up to judicial scrutiny because the amendments only protect people from the federal government. And, it can protect people from the state government. The problem is that the amendments cannot protect people from private sector, right? So regulating commerce, Congress can sort of put its thumb on the private sector and say, hey, private sector, businesses, you have to treat people the same. They have civil rights. You need to treat, you can't discriminate. So again, to reiterate that, the amendments like the 14th Amendment and the 5th Amendment that have equal protection clauses say that government can't discriminate against people. But the amendments don't apply to the private sector. So regulating commerce, Congress is like, oh, we can figure out a way to force the private sector to not discriminate. So the early test of this was Heart of Atlanta Motel versus the U.S. in 1964. Note that the case is in 1964, and the Civil Rights Act was passed in 1964. So the Heart of Atlanta Motel had this one geared up as Congress trying to pass the Civil Rights Act. So Title II of the Civil Rights Act prohibits discrimination on religion, national origin, race, and color. This type of discrimination was prohibited in forms of public accommodation that operated in or affected interstate commerce. So Congress is using explicitly the language the court uses to refer to their commerce authority. So an example of a form of public accommodation, motels, movie theaters, restaurants, right? But specifically, it was like motels with 5 or more rooms. So the Heart of Atlanta Motel had over 200 rooms, and they advertised heavily in Georgia, but they advertised elsewhere, mainly in the South, but sometimes nationally. Excuse me. The motel admitted that, first of all, yeah, we meet the definition of public accommodation affecting interstate commerce that's in Title II of the Civil Rights Act. 2, they said we were discriminatory before the Civil Rights Act. And 3, we are going to be discriminatory after the Civil Rights Act. So basically, black patrons couldn't stay at the Heart of Atlanta Motel. And they said, even after the passage of this, we're still not going to let black patrons stay. So the United States here says, look, this court has said that we're allowed to regulate local activities that influence interstate commerce. What we learn in Wickard versus Filburn is the effect doesn't have to be an effect on the litigants, right? This is something we also learn in Darby, that the thing that matters is the thing being regulated. It's not who's affected by the regulation. Regulations are allowed to affect people. That's what they do. So the way that the court has to look at these cases is not who's being affected. It's not, is the Heart of Atlanta Motel being affected? It's what's being regulated. And here the thing being regulated is that which influences interstate commerce. So the U.S. says Congress gets to decide if the party, here the Heart of Atlanta Motel, along with those similarly situated, that is to say, other public forums or public accommodations, are negatively impacting interstate commerce. Champion versus Ames says Congress is allowed to regulate social ills if they do so through something like the Commerce Clause. And here they're saying, discrimination is burdensome on interstate travel, on movement, on the economy, all these types of things, right? If there's fewer people moving through an area because they can't be accommodated, that's clearly affecting commerce. Ultimately, race discrimination is an economic issue. This is what I was just saying. If fewer non-whites engage in interstate travel because they're discriminated against, right, the economy or commerce is not reaching its full potential. The Heart of Atlanta Motel says the court shouldn't think of how the framers would think if they were alive today. They have to think of what they meant when they drafted the Constitution, right? And they say, the whole point of the Constitution was to limit the power of the federal government. Now, let me pause here and say that's true, but not when the Constitution is explicitly giving powers to the federal government, right? There are other parts that do limit their power, but drawing from Article 1, Section 8, the enumerated powers of Congress to say these are limitations is a little goofy, if you ask me. But to continue their argument, they say if Congress is allowed to tell us that we can't discriminate, then they can regulate everything. They can regulate all people and businesses however they want, right? So that's clearly not the intention here. They say something that is definitely true. They say Congress has not established a standard to determine if something materially affects interstate commerce. So the Heart of Atlanta Motel here is saying we kind of want, or we think that Congress should have sort of a formula or an algorithm that spits out an answer. Yes, this affects interstate commerce. No, this doesn't affect interstate commerce. Now note they're putting the word material in there. That's not what the court actually cares about. It just affects interstate commerce. But again, they think there should be sort of this algorithm. Well, that's not actually what the court asks. The court is asking for a rational connection, a rational basis between the thing being regulated and the thing and the way it's regulated, right? So the thing being regulated is discrimination, and the way it's regulated is via commerce. There is a rational connection there. Finally, the Heart of Atlanta Motel laments, basically this is a confiscation and a nationalization of motels, right? Okay, so the question here, can Congress use the Commerce Clause this way? And the answer, unanimously, is yes. So there's a couple portions of the court's opinion here. The first part is called the basis of congressional action. And the court says, if you go look at the legislative history, the conversations they had on the House floor and all that when they were writing the Civil Rights Act, they clearly connect discrimination and interstate commerce, right? The connection between those two things is meaningful. It's not nothing. So Congress shows that there is a basis for the idea that discrimination affects commerce. Okay. The second portion is the power of Congress over interstate travel. And they say, Congress does have the ability to deal with obstructions on commerce, but that sort of relies on how we mean commerce. And here they say, this is commerce that affects more states than one. So that has a real substantial relation to a national interest. So Congress is allowed to regulate here. Okay. So they say, previously we've determined that intercourse is the movement of people throughout states, right? That's the whole point of Gibbons versus Ogden. And they say, kind of following up on Champion versus Ames, Congress is legislating against a moral wrong, discrimination, but that doesn't make it any less commerce than something else. Just because there is a moral or social issue doesn't mean it's not an economic or commercial issue. It's not black and white. They can be intertwined. So here the court rules, it doesn't matter how local the operations are, Congress can prohibit racial discrimination. If the motel is engaged in interstate commerce, which here it is, then the actions apply. In other words, the activity does affect commerce. Right? So it seems that like the public accommodations with fewer than 5 rooms, it seems that those are deemed not to affect commerce. So it's really, it's not everything super, super micro, but it is sort of things that might be considered interstate commerce. So this is similar to Wickard versus Filburn, right? It's we're regulating sort of a micro level thing that ultimately impacts the economy, but there's no depression here, there's no sort of emergency here, there's no exigent circumstances. So this is a little bit different, even though it sounds a lot like Filburn. It is a little bit different. So here the court is saying, look, the thing being regulated doesn't itself have to be economic. It just has to affect commerce. So this argument that everybody, or at least one side makes in all these cases, this isn't an economic thing, this isn't commerce, that doesn't matter. Right? They don't have to be regulating the economy directly. They can regulate things that affect the economy. Right? So basically what we get here is sort of kind of a two-part thing that adds a little bit to what we know about when Congress can regulate. The court says pretty much, hey Congress, we're always going to let you do your thing if the reason you're engaged in some action is commerce and the thing being regulated is commerce. Right? Even if that's not economic. But basically they say, this is kind of the funny thing, they say, we'll let you regulate, but we also are just going to let you tell us that the thing that you are, the basis of your action is commerce, and the thing being regulated is commerce, right? So pretty much the court says to Congress, we're always going to agree that if you say it affects commerce, we'll say it affects commerce, right? That's not like a collusive thing. They're just saying Congress is the best body to decide if something affects commerce. That's not really the court's purview. So we're going to be deferential to Congress on this matter, right? Sort of saying Congress knows best about what is and is not commerce and what does and doesn't affect commerce. So we get this. Okay, so we've got these 3 categories to which commerce applies. So basically the first one is the use of channels of interstate or foreign commerce which Congress deems are being misused. Remember, that's some of the early cases where states are trying to interfere in interstate commerce. That one makes sense. They say the protection of the instrumentalities of interstate commerce, that's kind of the streams of commerce idea. We know a little bit about that one. But here's where it gets a little weird. They say activities affecting commerce. And that's what we've been talking about a little bit here in Darby, in Wickard, here in Heart of Atlanta. These are activities affecting commerce. But if you think about it, at the end of the day, what doesn't? What doesn't affect commerce, 2, 3, 4, 5 steps down the line? And ultimately, it was up to the court to kind of find out what's something that doesn't affect commerce and what's the limit. So sort of at this point, let me check that here. At this point, we're going to start moving into a couple of cases where we confront the limits of what affects commerce. Ultimately, all human behavior has economic consequences. Most human behavior has economic consequences. Right? If I go home and I eat a whole bag of chips, eventually I'm going to end up in the hospital for being, having a heart attack or something like that. Right? That has economic consequences. But it takes a long time for the court to sort of see these distinctions between what does and doesn't affect commerce. The court didn't find them. There really weren't limits for a long time. Let me tell you about this one case, and this is sort of where we'll wrap up. Daniel versus Paul in 1969. This is an example of a huge sort of very expansive use of federal power, and then the court allowing that. So there was this little club. I don't know if it was an Elks Club or something like that, but a little club somewhere in Arkansas that the court ruled was engaged in interstate commerce. There was no evidence that somebody not from Arkansas had ever been there, but here's why the court said that that little club was engaged in activities affecting commerce. They said it advertised in publications known to be read by some interstate travelers. I have no idea how the court would have determined that. They leased paddle boats from an Oklahoma company. There you go. Two different states. That's interstate, I guess. They owned a jukebox. The records were from an Arkansas company, but the records were not manufactured in Arkansas. And finally, 3 of the 4 snack bar items had ingredients that were made out of state. So these are really rinky-dink. This is definitely the broadest possible way to interpret affecting commerce and interstate. And this is not necessarily this case, but I think this is a good highlight of how sort of expansive the view of the reach of interstate commerce was. Ultimately, everything affects commerce. So as we pick up next week on Monday, we'll start to talk about when the court starts to see, okay, yeah, this has eventual consequences, but is it enough for Congress to be able to regulate? Okay, so this interpretation, this really expansive one from Daniel versus Paul, in 1969, its days were numbered. So where we pick up on Monday, we'll start talking about this case, Garcia versus SAMPTA, the San Antonio Metropolitan Transit Authority. Remember, you've got a quiz on Blackboard related to these notes. I hope you have a good weekend or had a good weekend, and I'll see you Monday.